Rather than continue the conversation with us, in September 2022, the NCAT board members signed and sent a document making many untrue and harmful statements about the MAT and its staff and directors. These errors were pointed out to them by an attorney for the individuals who were harmed.
This part of the rebuttal is going to be longer than the rest, but I'm going to try to make my points visually as far as possible. The intro to the September 23rd cease and desist letter does nothing to identify mistakes in NCAT's September 12th resolution, and so I'll blank that part out. Similarly, the end of the letter also doesn't spotlight mistakes, and so I'll blank that part out too. That leaves us with less than 5 pages of the cease and desist letter dealing with facts and rebuttal. I'll also blank out the non-facts portions of NCAT's resolution, which will leave us with almost 7 pages. Here's what we have left. And here's what we have left of the cease and desist letter. The portions in red boxes have to do with Steve Fenske. That's about 60% of the total. Here are the sections and paragraphs in NCAT's resolution that have to do with Fenske, about 30%, half as much. In other words, it appears that Fenske took personal offense to NCAT's resolution, such that 60% of the cease and desist letter dealt with the 30% of NCAT's resolution that discussed about him. For the rest of this section, we will mark NCAT's resolution in green and Matt's cease and desist letter in red wherever Matt didn't rebut our facts, evaded our point, or didn't respond to a request for evidence, where our facts were correct, or where we corrected an inaccuracy. Here's the portion of the resolution for which no comments were made in the cease and desist letter. Given that there have been no attempts to rebut these portions since the cease and desist letter of September 30, we may conclude that these portions must be fairly accurate. Here's a list of the sections Matt raised no objections to. A total of 10 sections out of the 20 sections the resolution contained. And here are some statistics. Now let's go through the rest point by point. Here's where NCAT's resolution points out that Matt's Form 990s filed with the IRS state that the 990s are sent to the board for review before filing, but multiple board members said that they never received them. The cease and desist letter responds that the 990s are prepared by auditors, which evades the point. NCAT raised no question about the numbers the 990s contain, but whether they are given to the board members after the auditors have prepared them. And so I'm going to mark that part of NCAT's resolution in green, since Matt has never shown NCAT's point to be incorrect. I'll mark the corresponding part of the cease and desist letter in red to show that it was inadequate. The next part of the resolution is about how a whistleblower told Mike Miller about an attempted improper payment of 2 invoices from Matt, purportedly not approved by the MATIT board. The cease and desist letter responded that Mel Milender said in an earlier board meeting that the extra costs should be paid and that the invoices were to be submitted to the board for approval. NCAT responded on September 30 that Mel said that the extra costs should be accounted for, not paid. The minutes of the board meeting in question record nothing about the matter. Mel also said that the invoices were intended to be paid without approval by the board. So whose version of events is correct? NCAT invited Matt to provide it with some sort of evidence that Milender's memory was incorrect, but has received nothing as of yet. So I'll mark in red and green those portions of the cease and desist letter and the NCAT resolution. The next point in the cease and desist letter concerns who the whistleblower could file the complaint with. In this case, both NCAT's resolution and the cease and desist letter weren't quite correct. The letter says that the complaint had to be filed with the first or second vice president and should not have been given to Miller. Here is NCAT's September 30 response showing this would be true if the complaint had to do with discrimination or offensive behavior, but not for other types of complaints. Here is Matt's complaint policy that was in force at the time. Here's where it says with whom a staff member may file a complaint about discrimination or offensive behavior. But here it says that only a board member or the executive director may bring other types of complaints. The staff member could therefore ask any board member to submit it, including Miller. Since Executive Director Krueger was involved in the conduct the whistleblower was complaining about, it wouldn't make sense to require the whistleblower to ask Krueger to submit it. And so I'll mark in red and green those portions of the cease and desist letter and the NCAT resolution. Next, the cease and desist letters say that Reno Wells didn't tell Mike Miller that he needed to file a complaint. Here's where the NCAT resolution stated that Miller's first version of his complaint was filed the day after Wells told Miller he needed to file a complaint. Here's the published minutes of the May 19 board meeting, which state that Wells told Miller he needed to file a complaint. Since the official MAT board minutes affirm NCAT's choice of wording, I'll mark that part of the resolution in green and that portion of the cease and desist letter in red. This part of the cease and desist letter objects to what NCAT wrote about Burdorf making unseemly comments by asserting that he wasn't the one who made those comments and that those comments weren't sexual harassment. Here's what the NCAT resolution says. It accurately describes what Krueger and Burdorf's lawsuit asserts that Miller alleged and believed. The resolution does not say that Burdorf really did make those comments or that those comments really do constitute sexual harassment. I'll therefore mark that part of the resolution in green and that portion of the cease and desist letter in red. The cease and desist letter objects to where the NCAT resolution refers to another attempt to transfer funds from MATIT to MAT by referring to the MATIT board's cap of $10,000 voted on August 12th. But the NCAT resolution stated that announcements at district meetings prior to August 12th left the impression that the intended amount was more than $265,000, $149 per township for every township in the state. The cease and desist letter failed to address this point. Here's a calendar of district meetings showing 5 district meetings occurring prior to August 12th. I'll therefore mark that part of the resolution in green and that portion of the cease and desist letter in red. Here's where the NCAT resolution said that Fenske filed a complaint, an immaterial point. The reality is that Fenske orally complained and Krueger filed a complaint on Fenske's behalf. Here's where the cease and desist letter said that Fenske orally complained but that he didn't file a complaint. NCAT offered to amend its resolution to say that Fenske complained and that Krueger filed a complaint on his behalf. To that offer, NCAT received no reply. After receiving the letters stating that NCAT would no longer be recognized by MAT and that the 5 townships were facing expulsion, NCAT issued an amended resolution on November 7 that contained this correction. Therefore, I'll mark that part of the resolution in green and that portion of the cease and desist letter in red. Here's where the NCAT resolution had a heading that said that the secretary was barred from recording the minutes. Here's where the cease and desist letter objected to the use of the word barred. We offered to amend the NCAT resolution to say that the secretary was removed rather than barred from recording the minutes, but pointed out that the meaning is essentially the same. NCAT received no reply to that offer. NCAT included this change in its November 7 resolution. Therefore, I'll mark that part of the resolution in green and that portion of the cease and desist letter in red. Here's where our resolution dealt with Krueger responding to emails sent to MATIT personnel when he has no position in MATIT. Here's where the cease and desist letter says that MATIT has no staff, that MAT employees serve as staff of MATIT, and that Krueger's oversight of MAT employees authorizes him to, in effect, supervise MATIT. Here's where the former job description of the MAT executive director includes supervision of MATIT. Due to a situation that arose before Krueger was hired, oversight of MATIT was written out of the executive director's job description. Here's page 1 of that new job description. Here's page 2. The job description is dated February 2021, the month before Krueger came on board. There is not one word about overseeing MATIT in it. Since the cease and desist letter fails to take into account the fact that oversight of MATIT was intentionally written out of the MAT executive director's job description, I'll mark this part of the resolution in green and that portion of the cease and desist letter in red. The next issue has to do with an inconsistency NCAT's resolution pointed out in Fenske's conduct. If the whistleblower was wrong in contacting Miller, then Fenske should have told me that he was going to contact the other NCAT directors behind the scenes. The cease and desist letter said that Fenske wasn't obligated to do so, but NCAT's resolution never said he was. The very real problem is that Fenske's communications behind the scenes came across as a divide and conquer scheme. Since the NCAT resolution never said Fenske was obligated to let me know he was going to contact the other NCAT directors, but was instead pointing out the inconsistency, I'll mark that part of the resolution in green and that portion of the cease and desist letter in red. We're down to the last part of NCAT's resolution, the part that dealt with Fenske's apparent violations of the R.P.C, the rules of professional conduct that lawyers have to abide by. I've marked in green those portions of this section that the cease and desist letter did not object to. The R.P.C require Fenske to provide competent representation and to not engage in dishonesty, deceit, or misrepresentation. This part of the cease and desist letter says that Matt is Fenske's sole client, but that his job includes providing legal information to member town officers. To me, that affirms NCAT's concern that Fenske should be providing accurate information to members' general questions. And so I'll mark that part of the cease and desist letter in red. The next part of the cease and desist letter asserts that Fenske's first statements were that he could provide only very limited legal information to county units. But Fenske's March 25, 2020 email says instead that he will be working on the question of what sort of organization a county unit is. And so I'll mark that part of the cease and desist letter in red. The next part of the cease and desist letter counters a misleading statement NCAT referred to in Fenske's April 12, 2022 memo on options for county units by saying that NCAT should never have seen that memo. Here's what the NCAT resolution said about the misleading statement. Since the cease and desist letter made no attempt to show that the statement was not in fact misleading, I'll mark that part of the letter in red and that part of the resolution in green. The cease and desist letter next complained that the NCAT resolution alleged that Fenske misstated the law about Minnesota Statute 366.01. But the NCAT resolution did not. 366.01 says that townships may pay dues to county units that belong to MAT. Fenske has stated that county units aren't part of MAT and aren't members of MAT. Then how is paying dues to county units legal under 366.01? Repeatedly, Fenske has argued that county units belong to MAT even though they are neither members of MAT nor part of MAT. The apparent contradiction is why my concern remained. On August 24, 2022, I discovered that all this time we'd been looking at the wrong statute. 471.96 permits the payment of dues to county units that don't belong to any other organization. My immediate thought was, why didn't Fenske tell me this 2 years ago? Since the NCAT resolution said Fenske failed to refer me to the correct statute that would have laid to rest my concern, and did not say that he has misstated the law regarding 366.01, I'll mark this portion of the cease and desist letter in red and the corresponding part of the resolution in green. The next part of the cease and desist letter attempts to show that Minnesota Statute 471.59 does not define the term instrumentality. Fenske, at the August 23, 2022 District 12 meeting, as part of his effort to shoot down my motion calling for a resolution to the county unit question, had stated that the term instrumentality isn't defined in state statute. But Section 297A.70, Subdivision 2D2, does in fact explicitly state that instrumentality is defined in 471.59. Fenske's April 2022 memo on the county units had also claimed that the term instrumentality isn't found in federal law or code. A simple search through the U.S. Code and the Code of Federal Regulations will return thousands of results. Since state statute does indeed say that instrumentality is defined in 471.59, I'll mark this part of the cease and desist letter in red, and the corresponding part of the resolution in green. Here the cease and desist letter says that Fenske did not know whether MAT existed prior to 1979, and yet our resolution made clear what Fenske already knew or should have known. The Form 990 state that he reviews the 990s each year. Page 1 of the 990 states that MAT began in 1933. I pointed out that the 990s state that MAT began in 1933 at the District 12 meeting on August 23rd. Thus, Fenske knew or should have known, or at least suspected, that MAT existed before 1979. Why is this important? Because MAT's 1934 incorporation papers state that its purpose was to create county units. If MAT created the county units, then it has an obligation to help them. MAT celebrated its 50th anniversary in 1983. It therefore could not have begun in 1979. I'll mark this part of the cease and desist letter in red and the corresponding part in the resolution in green. Lastly, the NCAT resolution states that Fenske has argued that county units should form a joint powers if they want to be legally recognized. The cease and desist letter denies that Fenske has ever argued that county units should form a joint powers. Here's Fenske's April 12, 2022 memo on the county units. Here is where that memo says that county units should be encouraged to form a joint powers if they want to exist as a legal entity. And thus we'll mark this last part of the cease and desist letter in red and the corresponding part of the resolution in green. Why haven't the NCAT directors been sued yet? Because there's nothing really in the resolution to sue over, and there's nothing in it to kick out townships over either.